The Justice Department has just released a document that was used to support the search warrant for former President Donald Trump's Florida headquarters.
The judge that approved the warrant ruled yesterday that the affidavit could be released after officials removed or redacted certain sensitive information. The Justice Department had argued that releasing the document could compromise its investigation. The judge sided with requests from multiple news organizations, including CBS News, to unseal the document. We have team coverage. Scott MacFarlane, Jeff Pegues, and Joseph Moreno joins us. Now, Joseph, I want to start with you. Just what do you make of this affidavit?
Well, I would have said this morning that I'd rather see something rather than nothing, right? Even if it's heavily redacted. Well, we got our wish. We got something. And it gives us a little more of a roadmap as to what happened here, but it's still a lot of open questions. I mean, I think what this further does is it builds the case that the Justice Department took steps leading up to this search warrant. And this seemed like a last resort. And there were many people that speculated that this may have been a sort of surprise, that the Justice Department went from 0 to 60 for no reason. What we've learned from the National Archives earlier this week, and now from this redacted affidavit, was that there were actually a lot of steps that the government took, both the archives and the Justice Department, to secure these records. And it did seem like they did their diligence and tried very hard. So now there's much more of an argument the Justice Department can make, like, look, we tried all kinds of things, and at this point, this was the only way we were going to get these records back from the former president.
A particular part of page 30 that is getting a lot of attention. The FBI said in this affidavit that advance notice of the release of this affidavit could allow criminal parties an opportunity to flee, destroy evidence stored electronically or otherwise, change patterns of behavior, and notify criminal confederates. We're talking about the former president of the United States, with the FBI making these allegations that they were concerned about this. What do you make of that?
Well, in all fairness, some of that is standard, right? They do have to establish that there's some exigency. Whenever you have a search warrant application, you've got to say part of the reason we need this and we can't rely on a subpoena or some other means is that there's a chance that evidence could be destroyed or moved. So a part of that is just standard. However, part of it is also, that's pretty serious, particularly when you're talking about, these aren't just presidential mementos here. These are documents that are classified at the highest levels. So yeah, no, look, it's significant. I think that also this dissolves another argument that's been made by many that this was about sort of, some documents that were no big deal. No, these documents were marked at the highest levels of classification, top secret and compartmented and above. So there might be a fight over whether they were properly declassified, and I assume that's probably where this is going to go if the Justice Department moves forward with any kind of prosecution. But there's no doubt that at one point at least, and possibly still, they were highly classified, and if nothing else, should not have been kept in an insecure location, even one constituting the residence of a former president. That's not a SCIF, and that's not an appropriate location for classified information.
Joseph, I want to stick with you, and we should know you're former prosecutor. And I don't know how much you can speak to this, but I guess the question on my mind is, why would former President Trump take these documents? Certainly he knew the proper procedure for these types of documents, classified documents, national security potentially.
Well, I mean, you might be giving him a little more credit than he deserves. I'm not sure he knew what the proper procedure was. I mean, he seems to adhere to this sort of pre-Watergate concept that presidential property belongs to the president, even after he or she leaves office. And he also seems to ascribe to this theory that declassification is sort of a snap of his fingers. There is broad declassification authority for a president, and it's significant. And I think that will be a very significant a bone of contention here in this case if it goes further. But I'm not sure that he actually followed the process, and I think that's what's going to come down to. So I think the classification and declassification is a key issue, but what's not really in contention is where these documents were. If there was any kind of legitimate back and forth or confusion or debate about the status of these documents, they should have been held in a more secure facility until that debate was worked out.
I want to turn to Scott MacFarlane right now, and I want to ask about the former president's response to this affidavit. I know you've seen it on Truth Social, the former president's social media service. He wrote, affidavit heavily redacted, nothing mentioned on nuclear, a total public relations subterfuge by the FBI and DOJ. We gave them much, all capital letters. Judge Bruce Reinhart should never have allowed the break-in of my home. Now, we've heard this kind of language from him throughout this entire process. What stands out in your mind when you see the president's response?
What stands out is the third line you're showing up there. In all caps, we gave them much. Doesn't preclude that he kept things he was supposed to give them. He didn't give them all, but also that he goes out naming the judge again, first name and last name. That's not happening in a vacuum. The judge has been subjected to a lot of scrutiny, a lot of online chatter, a lot of extremist language in chat groups and on social platforms, and the former president is feeding into that by naming the judge again and putting the judge's name out there. This judge is an officer of the court or a magistrate judge in the Southern District of Florida, and his name is being iterated by the former president in this Truth Social post. I want to mention the reaction we're getting now from Congress as well. The chairman of the Senate Intelligence Committee, Senator Mark Warner of Virginia, has issued a statement about the affidavit release. It says, it appears, based on the affidavit unsealed this morning, that among the improperly handled documents at Mar-a-Lago were some of our most sensitive intelligence documents, which is one reason the Senate Intelligence Committee has requested on a bipartisan basis a damage assessment of any national security threat posed by the mishandling of this information. You'll recall earlier in the week, some leaders in Congress, including those with a connection to the Intelligence Committee, said they'd like to see what might have been compromised with the nation's intelligence through the potential alleged improper storing and keeping of these records at Mar-a-Lago. That's not the last statement we're going to get today from members of Congress based on what the affidavit said, that there were records that weren't supposed to be at Mar-a-Lago that were there, that were supposed to be properly secured and weren't, and records that clearly had classified, secret, or top secret classifications. This is the start of, I think, going to be a wave of reactions to what the affidavit revealed today.
I want to go back to Jeff Pegues. Jeff, if you can just remind our audience, you've been reporting on this since the very beginning, how this started, the role of the National Archives versus the Department of Justice. You know, some on Trump's camp have said it's a witch hunt. Break it down for us.
When there is a change in an administration or in government, for example, you know, obviously Joe Biden won the election. Donald Trump has to leave the White House. And so the National Archives begins the process of cataloging everything that the Trump team had, because that is part of history. And some of these documents we're talking about that the former president had, you know, they're government property. It's classified information, top secret information, various classifications. And so whenever you leave office, that is government property. There are some personal mementos, but, you know, as we found out after the search, a personal memento / government document, the former president's passports, were given back to him. But there is classified information, top secret information that belongs to the government that the government keeps. And so that's why we're in this situation. You have the National Archives, who has the job of cataloging that information, making sure that it is in the right place. They referred this case to the Department of Justice because they knew that they didn't have all of the documents, because all of these documents are marked. There are records of them being given to the president when he's president at the time. And so they know what's missing. In fact, they also can figure out who's touched certain documents by fingerprints. And so the case was referred to the Department of Justice, and that's why the FBI got involved. And that's why, after several months and numerous back and forths and subpoenas, the FBI took the unprecedented step of going into Mar-a-Lago. And in part, if you look at this affidavit, this is the document, that was used to demonstrate probable cause to the magistrate judge, who then approved the search, approved the warrant for the search. On page 2, the former president on Truth Social says there was no discussion of nuclear information. Well, actually, on page 2, there is this talk of national defense information, okay? Classified national defense information that was contained in the 15 original boxes that were given over to the archives. And so in trying to get the warrant to search Mar-a-Lago, the FBI said, listen, we have probable cause. That's the legal term there to justify the search. We have probable cause to believe that additional documents that contain classified national defense information or that are presidential records subject to record retention requirements currently remain at the premises. At the premises in an unsecured manner. And as I've said before, Mar-a-Lago has been a target for foreign surveillance. And so if you're a government official and you know that these top secret, classified, confidential documents are being shared around Mar-a-Lago in an unsecured way, of course you're concerned. And of course you want to make sure that, all precautions are being taken to secure that information. But then when you go to the former president and his representatives and they sign a document that says, oh, we've turned everything over, and you know that they haven't, well, what are you going to do? You gotta search Mar-a-Lago, and that's why we are where we are.
Well, Jeff, you make a good point. I want to ask Joseph Moreno, in terms of the affidavit itself, of course, this is newsworthy and unprecedented because of the target of this, a former president. But in terms of the language used in the affidavit, is this pretty typical for what you would see for a case like this?
There's nothing typical about this case, right? Look, this is the first case against a former president, potentially. It's not the first case involving the mishandling of classified information. So it's certainly a lot of this is reminiscent of other cases where, classified documents or other materials were either mishandled or stored in the wrong place or taken out of a skiff or otherwise. So, yeah, look, there's so much that's redacted that we don't get to understand some of the theories. So we're sort of speculating a little bit here. But yeah, the degree of seriousness at this point is bolstered. And I've been saying myself, I want to give the benefit of the doubt to the Bureau, but I remain skeptical. Some of my own skepticism is reduced now because this is serious. This is significant. And it's clear the government didn't rush into this. This was actually not clearly a spur of the moment, things have gone quiet a couple of weeks, so let's execute a search. No, this was a long, drawn-out process where clearly there were steps taken leading up to this step. There was a grand jury that was convened months ago, at least. So that bolsters the government's position that, in fact, they tried many steps, and this was a last resort. And that undercuts Donald Trump's argument that he's sort of a victim of a persecution because, again, it's hard to argue that when the government said, look, we tried many things to get these records back, and this was our last resort, because otherwise it was pretty clear to us we weren't getting these records back.
I want to turn now to, thank you, Joseph. I want to turn now to Jessica Levinson. Jessica, hopefully you've had time to look through these 38 pages. And I just want to point out the obvious. The weight of what we're talking about, the potential for criminal charges against a former president of the United States. There's still a long way to go in this investigation. What are some of the next steps?
Well, I think you're exactly right to bring that up, that this is unprecedented. And in fact, that's why we're talking about the story on the whole, but it's also why we're talking about this micro issue, of course, of unsealing the affidavit, because there's a much greater public interest here than there is in maybe a quote unquote run of the mill case. But there also, because of what the investigation involves, there's really serious national security issues. And that's really what I think we learned today in terms of looking at this affidavit, is that some of the information here involves the most sensitive information. And that's really why I think the Department of Justice decided, let's stop asking for it. We're not getting what we want. This information needs to be stored in a much more secure way, and we have to get it. That was the exigency. That was really the timing. Now, in terms of where the investigation goes now, part of the portion that's redacted, of course, part of what the Department of Justice asked for us not to see is the roadmap for what happens next. And so I will say broadly, what we're looking at is whether or not the Department of Justice is going to go from where we were when they got the search warrant, which is probable cause. It is more likely than not that those 3 federal statutes were in fact violated, that there's evidence of violation of those statutes at Mar-a-Lago. How do we go from that to a prosecutor saying, I can prove to a jury beyond a reasonable doubt that those statutes were violated? If you look at the affidavit, I think on the document retention, they have an enormously strong case. What I'm really interested in is this obstruction of justice piece, and whether or not the obstruction of justice involves not turning over the evidence or the documents, or if it involves something else entirely, which I suspect it doesn't, but that's where I think I'd love to have more information. For completely understandable reasons, we don't have that information.
And we will continue to cover this, of course, here at CBS News. Jessica, Joseph, Jeff, thanks so much for your reporting and for your time.